Jeffrey Myers, CR 2025-1060. The time set for evidentiary hearing on jail calls, parties' appearances. We'll start with the state.
Rachel Stiles for the state.
Lane Myers for myself.
All right. And Mr. Parvin is your, not standby, I keep... Advisory council, sorry. So I want to address a few things before I hear from the parties.
Okay, we're live. Yay! This is an evidentiary hearing.
So I thought the hearing on Friday did not go particularly well with respect to the way the courtroom was supposed to operate. So, Mr. Myers, I thought that you were disruptive during the course of that hearing, and I want to address that for today's hearing. I don't want today's hearing to proceed as Friday's hearing did. First of all, your right of self-representation can be withdrawn. In Arizona, criminal defendants have a constitutional right to self-representation, but the right to self-representation is not absolute and may be terminated when a defendant deliberately engages in serious or obstructionist misconduct. Serious and obstructionist misconduct includes serious violation of court orders and rules when the conduct signifies that continued self-representation would undermine the court's authority and the ability to conduct the proceedings in an efficient and orderly manner. Before withdrawing your right of self-representation, I do have to give you clear, unambiguous, and timely warnings, which I'll do today. Conduct that can cause a defendant to lose the right of self-representation includes displaying utter and complete disrespect for the court, verbal outbursts, the tenor of those outbursts, consistent disregard of the trial judge's warnings, and wild antics in court.
Wild antics.
So some of the things that we're not going to do today is talking over me or over the prosecutor, swearing, calling the prosecutor or victim's names, continuing to speak when I have asked you to stop, threatening behavior, including trying to stare me down, encouraging others to harass the prosecutor, the victim,
staring,
or staff, being disruptive, talking faster than the court reporter can take down your
talking too fucking fast.
And,
oh
if
my
I find that you've
God!
done that, I will advise you to stop, and if you persist, I'll find that you've waived your right to self-representation, and then your lawyer will take over, and you will not speak at that point. If you continue to be disruptive, I'm going to order you held in a different courtroom, and we set up a Teams link so you can listen to what goes on in the courtroom. At the same time,
all the links to the history
Mr. Myers,
of this
you do have
is
the right of
below in the
self-representation,
description.
and I don't want to withdraw
Be sure
that
to
right
check
to
that
you,
out.
But it's up to you to act in a professional manner and not disrupt the proceedings. So with that, I'm going to start with the state because it was the state's request for this hearing as to Mr. Myers' phone calls with those who record those phone calls and then broadcast them, and the concern was that they could be used to harass the victim. So, Ms. Stiles, where are we on that?
Your Honor, I think Mr. Myers had something that to address the court with. He had his hand up.
All right,
so
Mr. Myers, what do you want to tell me?
Well, thank you, Rachel. I wanted to, when you're talking about the decorum and all that, I wanted to apologize for the last time and say I understand. I want to make it clear to you that I understand what you're saying and I understand my responsibilities as both the defendant and the attorney, especially since I'm about to become my own attorney and all this. And so the thing is that it's all new to me, so I don't claim to have a bunch of courtroom decorum experience. I do think I know somewhat about the law, but that doesn't mean that I can act a certain way.
Okay.
I want to say I'm sorry, and I do realize it's a tough situation being up there. To me, court is supposed to be adversarial, but not with the judge. Not. And when it's my turn to talk, that's when I can be adverse to their position, to my position.
Right.
And it wasn't my best day that day.
All right.
I want you to know that right off the bat.
And I know you're under a lot of stress. Everyone who comes to the courthouse is under stress.
Yeah, he's
You're
under
in
stress
custody.
because
you
he's
think
innocent
that you are being wrongly
and he's in
accused,
jail.
and I understand that. In part, we have to have decorum in the courtroom
I would be upset
so that
too.
everyone can be heard, and so one person gets to speak and everyone else listens while that person's speaking. So I appreciate that. All right, Ms. Dial, what's the state's, how do you want to proceed today, or what is your, what do you want to address?
Your Honor, so I was prepared to put up exhibits to show the live streams and then to play jail calls, also referencing that he, first of all, knew that he was being live streamed and that he was using that as a means to cause potential harassment then to the victim and then as well as the court. My understanding from Mr. Myers, though, is that he is agreeing that he will not be live streaming from the jail, meaning he's not going to call somebody else so that they can then live stream him on YouTube, and that he's agreeing to that during the pendency of this case. Is that correct?
All right. So the parties are going to enter a stipulation that the defendant will not live stream any calls from the jail? Yeah, go ahead. Yes.
Yeah.
Okay.
Thank you, Rachel. Yes, because after that hearing, during that hearing, it was, the first I had heard about it was during the hearing of it, right? So then, as soon as she brought it up, I saw the concern she had, right? And so to me,
No,
pull that down.
they're not hearing.
Sorry.
You gotta turn that.
So I got to speak into this.
It helps.
You gotta.
It bends.
It can bend.
Oh,
There
God.
Thank you.
have to be that close, but it just has to be pointed to you.
Thank you. Your Honor, when I was the message I was trying to get through to Rachel as well as you is that, okay, we're all adults, right?
Oh, no. Oh, no. I closed it. Frick. Ah. Okay, stand by. Shit.
You see these fucking ducks? They fucking love motherfucking freedom of motherfucking speech. This one is red, this one is white, and this one is blue! It's blue! Blue!
Oh, no. Alright, well, I guess we'll show. There we go.
Well, it might be a gray area, it might not. And now here we're at a hearing and last week and she's saying, I got a problem with this. So I'm saying, well, if you got a problem with it, I'll stop. And I obviously she can attest to this too, or whatever the word is, testify to this, that I haven't done it since, right? I mean, I haven't.
That's correct.
And I made sure that I'm telling people when I'm on the phone, do
Okay.
not contact the victim in any way, shape, or form. Reference the victim. Bring attention to the victim. And mostly, I'm trying to say that, like, I'll be straight with you. I was being critical of you, right? And so that's like one of the things. And to me, it's like, well, if it's simple as protecting the victim, that's different than the court, right? It's two separate things here. Like the victim is a higher priority than necessarily the judge hearing that I didn't like his ruling on the slap or something, right? But that doesn't mean that I can't agree to that, because if she's going to play a conversation where I'm making condescending remarks about you, that's going to open it up for you to have a, not that you can't remain impartial, but I think the best for everything is Lane, just stay off YouTube.
Okay. Well, with that, I don't know that we need to address that. If a problem comes up in the future, we can address that in the future. Was there anything else? We're going to talk about the schedule a little bit, but anything else we needed to address today?
Your Honor, just that this came up in one of the videos is by the YouTube person that he's been in contact with. The disclosure that we provided was then somehow provided to that person who then had shown it all on his YouTube channel. And under Rule 15.4 of the Arizona Rules of Criminal Procedure, subsection D.
D as in David?
Yes. Disclosure provided in this case cannot be disclosed publicly. So we have an obligation to provide the disclosure to Mr. Myers, and he needs to have the disclosure, but that disclosure then cannot be given publicly. And this was back on March 18th that happened. And so I just want to make sure that that's clear to Mr. Myers so that he understands it and is aware of that rule so that we don't have that issue come up.
Mr. Myers?
I both agree and disagree with some of that stuff she's saying. First, I want to clarify, like, as she did say, as Rachel said, that was before I was in custody. So I obviously haven't been able to do that since. But also, that kind of falls back to that thing with child publicity. Police reports are public information. I realize there's a gray area with the 15.4D. I'm very familiar with that from different cases, but it also, under again the child publicity, I do have the right to talk about the police reports and certain disclosure, not all disclosure, but certain things that are a matter of public record. Anybody could go get a copy of that police report from the police department and pass it out. Now, I understand the concerns of me giving it out, and again, it's the same thing. I'm not in jail, so it's going to be kind of hard to do that. Or, I mean, excuse me, I'm in jail now. I wasn't then. And, you know, the press does have the right to the public records, but also we have to find a balancing act between, you know, disclosing things that influence the public and just disclosing matters of public record. And again, I'm not fighting to this isn't the hill I want to die on, for lack of a better term, about, I just want the disclosure, and I feel like specifically the reason, and I'd like to address this with Rachel, because maybe something needs to be done, but the police report says that I was their ex, right? And that's why I released it, because it literally says in there that Shannon Walker's my ex, right? And that's a police report signed under the penalty of perjury, okay? And that's a public record, and I wanted to, and I feel that's the very spirit of Rule 3.6 of trial publicity, is to correct misstatements or miss things. And if I'm out here charged with domestic violence and charges related to having a romantic or sexual relationship with this woman and I never had, I felt in that moment, release this police report where it literally says, my ex, Shannon Walker. She's not my ex. And I felt for the public to know that I'm being charged if she's my ex, this is why the police report says that, not because it's true. And so, like, I agree with Rachel. It's not, we don't need to litigate the case in the YouTube channel, you know what I mean? So, like, if Rachel wants a strict interpretation of 15.4, that's fine, but also, technically, it needed to be redacted, and you can share some of it, and there was no court order saying I couldn't at the time, right? Now, I realize that the court can impose those conditions. At the moment, there wasn't, right? But, so that defaults back to Rule 15.4 as a default, right? They release it, they say 15.4.
Oh, did I lose audio? God dang it.
Or you can't release it. That balancing act of, well, how much of this do I need to release to make sure that the public knows that's what's really going on? And how much of this are you just doing to just do it, to just, you know what I mean, put everything out there? And so that's where, again, I'm an amateur when it, you know what I mean, this is my first, so I'm not against, you know, working with Rach saying, oh, because obviously I'm in jail, I won't be putting nothing out from jail. I just want to make sure that she's referring to, like, publicly on YouTube. There should be no reason I shouldn't be able to, like, talk about the police report with my wife or my friend on the phone or, like, an attorney consultation type thing. I believe, if Rachel, correct me if I'm wrong, you're more worried about, like, public, like, out there on the public, like, domain, right? Like, out into YouTube type public domain?
Yes, the rule specifies about putting out into the public. And so even though that these are police reports, I don't consider them public records. I don't think the law considers them public records.
It
If they were to
does.
get them from the police department, there may be more redactions that would come if they did a public records
If you
request
can
than what
request
happens
it.
when I give them to the defense.
That's a
And then
public
the other
record.
issue is
Let me ask this, when you disclose them, are they completely unredacted?
No, so we have to redact the victim information and anything that's considered egregious. So those are the things by law. So we don't have body-worn cameras in this case, but if we had a body-worn camera and they had their computer displayed, that has to be redacted. And then victim information always has to be redacted out. Everything else
That's up
is
to
in
the
there. So the
department that
concern
handles
wasn't
the
just that
record.
one police report he's referencing. It's that there were emails that have been sent, and they have been both supportive and, you know, against the victim in this case. And their information's all being put out in the public domain, which is also then leading, you know, that the public could then contact those people or contact witnesses, contact people involved in the case and try to intimidate people in the process.
That
And what
didn't
was
happen.
happening on that channel is people that were in support of Mr. Myers, they were redacting their information and then leaving the other people's information, which is suggestive that it's being used. And I'm not saying Mr. Myers did this, and maybe the person he sent it to is then putting it out there where it could lead to intimidation of witnesses. And we
could
just want to
lead
make
to
sure that we
intimidation.
keep the process, you know, clear of intrusions from outside people who don't know the situation and are trying to influence the process. And then I just want to address his issue with the one police report that had the error in it. That law enforcement officer no longer works for the agency, which is why there hasn't been anything filed to change that. So that's
Also,
the
because they
information
can't
the
they can't
detective
fix
gave
it
me
because
about
the
it.
guy who fucked it up isn't
Mr.
there.
Mayor, a couple things police
That doesn't
reports
make
can be
sense.
accessed as public records. What I hear from the state, though, is that when they do it, they may make more redactions than are redacted for disclosure.
Less.
Okay, well, I can't, I don't have it in front of me to know exactly, but I guess what I'm saying is that 15.4D does prohibit you as a litigant for when you get information in disclosure, you cannot publish it to the public. That's different than if someone else goes to get a public record, what they can do with it. That make sense? In other words, when you get it as disclosure, this rule applies, even if someone else could go down to, what is it, 40 South Zone, 20 South Zone?
600 or something. I know what you're saying.
And get that themselves. So, I
Okay.
think we're just talking
So
about.
then what's the issue?
Going forward, just to admonish that 15.4D does preclude you from disclosing the information you receive in this case to the public. That make sense?
And then, Your Honor, on specifically the grand jury transcript, the grand jury transcript is itself a protected document. And so again, Mr. Myers may not have been aware of the statute, is that he can't just be reading and talking about the results of that. And so I want to caution that just because, he's going to get another grand jury transcript, I just want to make sure he knows that that's actually an offense.
I'm not aware of that.
Okay. And that's one of those things, you wouldn't have gotten that, but for your status as a litigant, that's why you got it. But there are statutes that provide that those can't be publicly disclosed. So the inability to produce information to the public would include the grand jury transcripts. Yes.
I just wanted to clarify something for the record, and I'm not disagreeing with Rachel, but the police reports, when you go get them from the police department, they actually are not redacted. The victim's information would have been shown, and on top of that, we went out of our way to redact every single one of those emails. I want the record to reflect. If you put that video up right now, I made sure, I said, do not release this without redacting it. So the channel she's talking about spent hours redacting all those emails. They might have shown like the first part of a couple, but not there was no way for anybody to watch that video and email anybody off that video with the complete email address. But I'm not sitting here trying to nitpick with Rachel either. I get her point too.
Okay. All right. So that we've addressed the 15.4D issue. Anything else we need to, and again, I'll talk about the schedule here in a moment. Anything else we need to discuss?
Your Honor, are you able to do his arraignment today? I believe the documents should be now available to the court so that we could do the arraignment.
Please.
I looked it up, and only the first page of the indictment was available. Let's see if I can just change it all. And I don't, what happens with an indictment is that it's a printed document that's signed by the grand jury foreman and the prosecutor, and then that's uploaded, so it's not electronically filed. So let me look again.
Yeah, it's only an agave showing the first page.
Yeah, and that's what I'm saying. Somehow it didn't all get scanned in when it was.
I don't know if there's a way for the court to get it. I just think it would be better for everybody's time if
Agave is the only access I have.
Okay.
So.
Friday.
Yeah, so it's Friday. Well, why don't we, again, I don't want to go forward in the indictment, arena on the indictment, because I'm not confident that there's only 3 counts, for example, and I just got through the whole document. And, yeah. So, again, Mr. Myers,
More
what I got
delay.
was page 1. That's what's
I
on.
haven't got anything.
Yeah, you
While
don't,
he sits in
this
jail.
is on Agave, but it doesn't have the whole thing, because there's obviously got to be a signature page as well, which I got to make sure that it's been signed properly before I can arraign. So,
Can you clarify something about the sorry, because again, first grand jury transcript thing.
Right.
There's a rule that says you can't talk about, or like that can't be like released to the public. Is that what the contention is, Rachel?
It's a statute, is it not?
It's a statute,
Okay.
and revealing it's a class 1 misdemeanor. So
Okay.
that's why I just want to make
Ever?
sure that.
Like ever revealing
I think you have to get court order to.
Yeah, it has to be under court order that can be released.
Okay.
That's why I just want to make sure that Mr. Myers was, put on notice
Sure,
of that,
sure.
so he knows.
I didn't even know that. So unless there's a court order, it's private.
Correct.
It's considered like sealed or something type thing.
Yes,
Okay.
exactly. All right, so I'm going to leave it to one of the hearing officers to do the arraignment on Friday. And then in this case,
Because we'd also like to set the next, like, representation here at the same time if possible.
yeah, so in our case, the first case, I'll say, we have a case management conference on the 15th. You could file a motion, Ms. Stiles, to accelerate the case management conference in the other case. If you could do that, and then we could get them both on the 15th, or set a status conference, whatever you want to. Or I could set a status, well, can I set a status conference, I guess, before he's arraigned?
So at the arraignment hearing, we can just make sure it gets set on the 15th
Okay.
along with the other case.
Can you make a note, whoever's covering arraignments, to do that?
Yeah, I'll be there.
Oh, you'll be there, okay, all right.
So I'll make sure that they get
Okay.
put together.
All right, so, Mr. Myers, what's going to happen is, the case management conference is the first court hearing once you're held over for trial. And at that, we'll talk about the status of discovery, and I intend to also do the pretrial conference so we can set that trial date. At the arraignment on Friday, Ms. Stiles will be there, and she'll ask the judge to set a case management conference and pretrial conference on April 15th in the new case. So when we come here on April 15th, both cases will be here. And when we set hearings, they always have to give notice to the crime victims, and the crime victims will be notified that the April 15th is the next court hearing, okay? Sure.
Can we do the Ferretta at some point in Friday or what?
Let's do that on the 15th as well.
Okay.
Yeah.
And if he files anything, now for the one case number,
The current
case number, and then I imagine a lot of the things that he would file for the first case number would also apply to the second one, then he can just do a motion to also put it under the other case number. That would be fine.
And I'll, let's just do that. And we'll make sure, Mr. Myers, that if you're filing something that would address both cases, that I'll make sure that it covers both cases.
They won't.
I intend to, I'll just tell you, as of right now, unless something happens between now and the 15th, I would intend to allow you to represent yourself, but we have to have that formal hearing. But you haven't been arraigned on it, so
It's kind of like a procedural.
it's a procedural thing. And there's what's called regular order, that we have to follow these rules. And I know that it's like, I just want to get to this point, but we just have to do it, okay?
May I say something, Your Honor?
Yes.
On Fridays, it's just an arraignment, matter of semantics. Usually, that's just covered by the standing attorney. I don't know if the court needs me specifically for an arraignment, just to say we're ready for the next court date.
Any reason why
Usually, it's standing and arraignment attorney.
Yeah, so there's always a defense attorney assigned to those, so that's
Yeah.
up to them of whether they want that person to stand in. The release conditions are already set because of the no bond hearing, so
Right.
it's
Okay.
only the
See,
arraignment, but
Mr.
that's
Myers,
up to them.
Mr. Myers, you're
I don't mind being there, but it's double coverage.
What's the date? Friday date.
Friday,
The date.
the 4th. That's the arraignment. So, Mr. Myers, you have no objection if just the covering defense
No,
counsel?
because it's just procedural, right? Arraignment.
Correct.
And then we can get to the Ferretta and all that.
Correct,
Now,
on
they
the
did
15th.
say, he asked me to say something about a settlement conference. That's something that he just whispered in my ear.
So, Your Honor, I'm not sure where Mr. Myers is, if he's interested in a plea agreement or not. It seems like that's gone back and forth of whether he is or isn't.
He is
I would
not.
suggest
He
a
has
settlement
never wanted
conference,
one.
So we can just schedule that,
Okay.
at a time that works, and we'll just make sure that that Mr. Myers is transported for that. So that's up to him. But I don't want to have a settlement conference if he isn't actually interested in discussing.
Would you be interested in
possible
it?
Yeah, I mean, I would sign a plea bargain today, but I was told yesterday that Rachel doesn't want to do that for a few weeks.
Okay, remember we talked about the separation of powers?
Why not?
Okay, maybe
And
not.
and
I don't
Just
know.
hold on.
I'm not getting-
One of the things is,
I thought I knew.
only the state can decide whether to offer a plea or not. I'm not involved in that. You can go before a different judge, not me, to talk about a plea. Again, that's up to you all. At the same time, remember, you want this set for trial as quickly as possible, and I think it should be set for trial as quickly as possible. That sometimes is inconsistent with plea negotiations, which can go back and forth, and we have a victim in this case, so they have to reach out to the victim. But I think she's going to set a settlement conference, and she can make a plea offer if the state wants to.
Is that like
Get
an
it-
open court?
It's a written offer, and then they give it to you as a document.
Okay. And it's not the trial judge?
Oh, the settlement conference is before another judge. It's off the record, though.
Okay.
It's not live streamed or.
Perfect.
It's
kind of like a civil thing too.
correct. Correct. If you take a plea, that's obviously on the record.
Oh yeah, for sure. But I
So-
mean the discussion itself, and it's confidential, right?
Yes.
Like when I also have the obligation to not leave that settlement conference and talk about it, right?
Correct. Yeah, it's confidential, and the reason for that is sometimes people will speak frankly about the case, and they don't want that to be used against them at trial.
So
And so
there's like some kind of rule that says that what we talk about can't be used against you.
yes,
Yes.
it's
Okay.
is it 408 or 411?
Okay.
Yeah, it's in the evidence rules.
It's in the evidence rules and the chapter 400 series.
So it's kind of like civil. Anything we talk about, any monetary, all that, can't talk about.
Right. Right. It can't be used against you.
Thank you.
All right. So we're going to be back in court on April 15th in this case.
And Your Honor, one more. So Mr. Myers let me know. I didn't know that the jail no longer has a specific law library. It sounds like they've changed that to their tablets, but it sounds like he may not have access to that. So I'm going to talk to a lieutenant at the jail to just make sure that Mr. Myers has access to everything he needs so he can do his research.
Right.
I don't know if he has paper and pen yet. It sounds like OCAC, if he's not able to get that,
Thanks if you tell me what you need.
that Mr. Parvin can work with OCAC and
You don't have any pens at all.
the public
I have
defense.
nothing.
So that he can work with the public defense services to make sure that he is supplied with paper and pens as needed so that he can then take care of those issues. And then they also can supply Mr. Parvin with a computer that can play everything so that he has access to make sure he's able to review all the disclosure.
Okay.
So I think that hopefully will take care of his issues with not having access to things for him to be able to represent himself.
All right.
So if there are further issues, they can just notify,
So
notify if there's an issue so that we can make sure it gets resolved.
This is how you search for a hearing.
Mr. Myers, one reason to have
Every day this
advisory
is updated.
council is if you have issues like that, you can call Mr. Parvin and say, hey, I can't get this, this, and this, and then Mr. Parvin can work to do that. That's an important part of what advisory council does. But you have to tell him, and it sounds like we're going to get that set up.
Yeah,
If it's not,
I get some paper.
Because once you gave the official, like last week you said there's an order now to go to the law library. Well, I put something in and they go, oh, we got rid of the law library 2 years ago.
yeah, they have to have something there.
Yeah, so I wasn't aware that they got rid of their official law library, but it sounds like they're doing it through the tablets. But I will find out and make sure that he has access. And if there's any issue that he's not getting access, I'll notify the court so the court can enter whatever orders are needed.
Yeah, because that's important, obviously, that he. I don't know the
Thank you,
exact.
Rachel. Thank you.
I don't know the exact state of the law, but obviously he has to have the ability to do legal research for his defense. And then whether that's through Mr. Parvin, through paralegal, or how they do it, I don't know that. I'm not making a ruling on that, but we need to track that down.
It's funny
so
because
that
on their
that's,
website it
addressed.
says
The
that
court
the tablets are
allow-
given to
I mean,
people for
allow
free
handwritten motion?
and
Is
that it's used
under
for
that understanding?
education
You can do handwritten
and
motions as long as I can
communication.
read your
People can
handwriting.
even get music as long as they pay
I'll
for
tell
it
you-
on
They
these
don't have any other
tablets.
option.
Yeah, just the other
According
thing you
to the
could do is you
website.
could give a handwritten motion,
Mhm.
and Mr. Parvin could have it typed up. I take it as that.
Very busy, and he's a one-man
I
show.
Well, I could. If it's something
I
you
just
agree
saw
with,
it the
I don't
other
mind if
day.
your name on it, I can type it up for you if it's something you want to write.
Yeah, I mean, I'm just telling you, it's
It's
better for
unique.
you
No,
if
I
I
know.
could read it. Okay,
Oh,
I'm just
well,
telling.
I agree. But I mean, I can put, a heading, Superior Court, blah,
Yeah.
blah, and you're cool with it being handwritten and stuff.
Yes.
Right, okay, thank
Yeah,
you.
and
I
there's
just need
ways-
paper. I just need a way to write it now.
Right.
And I just want to clarify that.
Here it is,
I know we're on the
tablet
other case, but I'm
services.
still appointed on that case until April 15th. If I decide
It's
a motion
to
in the best
access
interest, I believe
family
I
and
can still file at this
friends
point.
as
Yeah.
vocational
No, no, no,
training,
no, I agree
messaging,
with
and
that.
multimedia
Yeah.
content.
Yeah, that's fine.
In the last hearing, they were trying to figure out how can we get this
In that interview,
multimedia
right,
to
no,
him.
Right, exactly.
Oh, gee, maybe the
Mr.
tablet
Parvin's
that they
still the attorney
say
of record
that
in
that's
this
what that's
case
for.
matter.
And that's kind of why they also said the
Multimedia
law library
content.
is still like I think what she's
Music,
saying is about
movies,
they're
and
gonna give you
games.
the tablet for maybe more time than the other inmates or something. Maybe that's how the law library.
It also
I-
says,
We all
look,
got to share the tablet. and
supposed
it's
to
like
get
only 25 people sharing
one
a
free
tablet, and if I
visit
need to
per
sit there
week,
for 2 hours and do legal
a
research
video
and write
visit.
down a motion and all that. It's kind of like I'm not really
Right.
special enough to
Mhm.
take away the privileges of somebody else calling their family or something.
tablets
and so,
will be provided
as
at
long
no
as
cost.
Go ahead.
I'm sorry, I didn't mean to interrupt.
Well, it's like, so I feel like it sounds like Rachel's gonna do her due diligence and try to figure out a way that I get like a dedicated time where it's like, you get to use this right now to do the law stuff.
Yeah, I think she's going to look into this, and if it hasn't been resolved, we have to come back to court. We'll have to have someone from the jail here to go over that. So that it's an important part of your defense. Okay, so we're going to come back on April 15th, and I think we'll have the two cases. And I don't know if that so
This
that
is
means
all
I'll
supposed to
call
be
both cases.
evidentiary
They're two separate
hearing.
cases. There may be a motion to consolidate to try it all at once.
Sure.
Either side.
Okay.
There's a rule of criminal procedure allows for consolidation. So someone might want me to make.
Are you gonna file that?
Might want to make that
They're
motion.
just gonna keep making
if you want to try it
charges
all at once,
so
or
that they
or
can
to
never
trial. I'm not
fucking
prejudged. I'm just saying that should
go
be
to
addressed.
trial because they
Yeah,
just
if we
keep
want
adding
that,
more
if Rachel,
charges.
You want to file it? We stipulate. I don't know how you want to do that. If we each need to file a motion or what, but if it's stipulation, whatever.
I can put in the motion and then put his position into it.
Okay.
Thank you.
All right. Anything else? All right. We're going to see you back on April 15th, and that's on the 9 a.m. calendar. Correct.
April
Thank you, sir.
15th,
That we're
9
doing
a.m.
Have a good day, everybody.
You too.
Well, so there was no. I mean, I'm not sure what evidentiary hearings are supposed to be for, but I thought there'd be some evidence. I guess not. I don't know. Alright, so if you go to this, the Pima.gov website, it's www.sc.pima.gov, and you go to the Court Services tab, you can listen to any court hearing. Today in particular, I was interested in the Lane Myers hearing, just because I watch a lot of First Amendment auditors, and I've been watching his channel for a while and all of his legal battles, of which he's had many, of which he's won many. So you can go here and you can put the name in, or if you know the case number, you can put it in there, and it'll give you the link. And this will link you to the YouTube page. This is the live stream that we were just watching. So yeah, that's how you do that. Here you can look up the previous cases, and you'll see that, no, dismissed by prosecutor. Interesting. What about this one? Oh, dismissed, request of prosecutor. I'm not sure about this one. I don't know. That one hasn't been, or it's been transferred. So yeah, that's it, y'all. I'll be watching this case, keeping up with it. It's very interesting to me. He was basically arrested for exercising his free speech. So, you know, that's a slippery slope, y'all. And that's why I'm just sharing this information. Like, I'm not even really like a news channel, but the more people that hear about this, the better. Like, when people don't want things to be seen, it's because they're doing bad things, right? And so if they're doing right and everybody's doing right, then nobody should care that this is getting shared out to millions of people all over YouTube by several channels. And, you know, if you've got a channel, post, you know, become active, because, you know, our rights are slipping and we can't let that happen. If this continues to happen like this, like, that's not the world that I want to live in. So, like, this is the country, you know. So yeah, thanks for watching, and I'll be doing some more of these in the future. I'll be covering the April 15th thing as well. So yeah, leave me a comment, tell me what you think. What do you think